Hey, I've got some great news to share with you folks if you haven't heard. You haven't heard? Court TV is back. We are relaunching May of 2019.
To the new law violation, $500. As to the VOP, 10. As to the new law violation, 5. As to the new law violation, 1,000. As to the new law violation, $500. As to the VOP, 10,000.
Defense position.
Judge, I agree with the request on the new charge of $500. However, I'd like the court to consider no more than $2,500 for the VOP.
Well, the charges may have been different, but in the same case, just from this, it appears that she posted 6,000 originally on the charges. It came in as possession of cocaine, possession of drug paraphernalia. Can you confirm that, clerk, that the original bond amounts in that case were a total of 6?
One moment.
Yes, ma'am. Maybe I'm mistaken about that. Let's see. $10,000 seems eminently reasonable in this matter. 10,000 cash or surety on the on-site violation probation, 500 on the possession of drug paraphernalia. Don't possess any illegal drugs or illegal drug paraphernalia. Appear for your next court date on the new charge on January 29th and on the violation of probation on February 18th, as reflected on the paperwork I direct you to sign. What are other than the regional conflict counsel?
Turner.
If you want to do Mr. Turner, we can do that.
I think that's it.
Turner.
Mr.
Yes,
Turner.
Mr. Turner, would you come on back up?
The plea.
Yes, sir.
Mr. Turner was acknowledged that there appears to be some warrant for his arrest out of state, and that I gather what he was thinking of doing was getting this pled to here. But here's the problem that I have, and I'd like to address this with you, Mr. Turner. You're not represented by an attorney here.
No, sir.
And if you enter a plea of guilty or no contest, that may affect the violation of probation is it Arkansas?
Yes, Your Honor.
Okay, let me explain. Mr. Turner, would you agree that on a violation of probation, the state would have to prove to some extent that you violated your probation, right? If you enter a plea of guilty to this charge, rather than proving that you did something, then maybe all we may have to prove is that you pled to it. And see how much easier it make their job if you enter a plea of guilty in this case.
That's okay. That's okay with me, Your Honor. I know what I'm looking at back home. The parole system is way different than here. We have a point system up there, and I'm going to accept it. Whatever they want to do about it once I get home, that's fine. I just want to get this over with, go home, do what I got to do, and go home to my family. That's it.
I know you think that you know this, but wouldn't it be prudent for you to talk to a lawyer?
No, sir. No, sir.
Let's see what the state. Do you have an offer on this matter?
Yes, Your Honor. The state would offer 30 days of Brevard County Jail for credit time served, $130 of cost of investigation to the Cocoa Beach Police Department.
All right. So what if
he'd be adjudicated guilty of this? He'd be convicted on this charge, and there'd be mandatory court costs, another $275 approximately that I'd be required to order him to pay. Right.
Right. But what if Arkansas shows up to get me during them 30 days? That's my question.
No, you'd have to do the 30 days. Then they would be notified after that to come get you. As soon as that time was triggered, the time was over, then they'd be contacted to get you.
Okay, so if I don't plea out and they show up in 10 days, and then what?
If you bond it out, they may pick you up then.
Not bonded out, Your Honor.
Yeah.
If I didn't plea out today, all right, and they showed up 10 days from now, and I still hadn't got this dealt with, what would happen? Would I leave with them? I mean,
Here's what I believe. I can't give you any legal advice, but
Right.
my understanding of the procedure would be this. If you bond out, they execute the warrant and they pick you up. If you remain in the county jail awaiting resolution, they don't pick you up. If you plead to it, they pick you up when your sentence is over.
okay. Well,
Did you want to talk to a lawyer about this?
no, I just want to get it done. I didn't really think it was carry that much time. I was hoping, that they would be here.
Why don't you hold off on it then and talk to a lawyer and see if they can arrange something more favorable?
Here's the deal, Your Honor. I'm not from here. I'm from Arkansas, okay? I have no phone numbers. I have no way to call my family. I have nothing here, nothing. All right, so there's
Bear
no...
with me on this. Respectfully, Mr. Turner, if I appoint a lawyer to represent you, they can contact your family. You contact them, they contact your family.
Okay, so if I post a bond on this, then I can leave, right?
Well, they as I said, if you post bond, they may execute the warrant. Then they may pick you up from Arkansas.
Okay.
But look, I can't give you any legal
Right. I
Why
hear
don't
you.
you talk to a lawyer?
I need
My advice to you is to permit me to appoint counsel to you. It's not legal advice to say you need legal advice.
I'm taking your advice, Your Honor, and I accept it.
Okay. Does he qualify for the appointment of counsel?
He did not fill out an application.
I didn't even fill one out.
Fill one out. We'll talk again when you've done that, okay?
All right.
Other than Mr. Turner, any other passes that we have other than Regional Conflict Counsel?
Goolsby, Hatcher,
Okay.
Austin.
Gould. All right, why, we passing Goolsby? Go ahead and have Goolsby come up.
I was to contact Mr. Feinswag, I believe.
Goolsby. Could you refresh my recollection? Well, Goolsby who represents you in this case? That was David Feinswag, but that was Regional Conflict Counsel, right?
Yes.
All right. Other than calling Regional Conflict Counsel, is there any other passes other than Mr. Turner?
No, everyone else is to contact an attorney.
All right. Thank you. Give me a moment.
We done with Miss Goolsby?
Or now, I think.
Thank you for calling the Office of Criminal Conflict and Civil Regional Counsel. Someone will be with you shortly. While you wait, please make sure you have your case number, attorney's name, and any other information that would allow us to help you find the information you need quickly. Thank you for holding. Office of Regional Counsel, this is Mary Jo.
Hello, Mary Jo. This is David Silverman here at the Moore Justice Center conducting initial appearance proceeding. There are a couple folks who have been appointed to your office that I'd like to have counsel address, and one of them is I had spoken on the 8th, 2 days ago, to Mr. Feinswag about Kadira Goolsby. If he's available, I'd like to talk to him.
Certainly. Let me get you through to him.
Thank you.
One moment. Thank you, sir. I'll put you through.
Thank you.
You're welcome. Hi, this is David.
Hello, Mr. Feinswag. This is David Silverman here at the Moore Justice Center.
Good afternoon, Your Honor.
Good afternoon, sir. I'm conducting initial appearance proceeding. We had spoken before about the case of Kidura Gouldsby.
Correct. And I don't have any additional information for Your Honor, unfortunately.
Very well. I'm going to go ahead and leave Ms. Gouldsby in the no bond status, endorsed on the warrant, and there's another case as well. Give me one more, please. That was what's the one moment. What's the other case?
Is 17-31100 CFB. That's a grand theft retail. And then there's 1735288 CFA, and that's a grand theft.
Am I correct in understanding that there's no bond endorsed on the warrants in both these cases?
That's my understanding.
Okay. I'm gonna leave her in the no bond status, endorsed on the warrants.
Your Honor, I'll get with Ms. Gouldsby and we'll get a bond hearing.
Very well. Thank you. There's appear for your next court dates amendment is reflected in the paperwork I direct you to sign. When would that be, Kara?
It's previously set for January 16th in front of Judge McKibben.
That's the earliest of the two, right? Or is that both of them?
Both.
For both, Your Honor.
For both. Very well. Thank you. That's less than a week away. Thank you. Quentin Hatcher, I've appointed your office, Mr. Feinswag, to represent Quentin Hatcher, who's standing at the microphone here. If I give you a case number, could you check to see if you have access on this?
I can, Your Honor. Let me just make sure I'm still... Okay.
2019 MM 11025.
The arrest affidavit actually is not in Beckett just yet. There's nothing to view, so.
Are you at your computer where you could receive email?
I am, Your Honor.
Would you check your inbox to see if you have received the email that I just sent that includes the arrest report?
I just received it. Thank you, Your Honor.
Very well. Once you review that, let me know when you're ready.
Yes, sir. With the minimal amount of information, I just can't tell whether they have the right to keep him at the vehicle, but other than that.
I understand. There may be some motions appropriate to be made later on. At this point, I find probable cause. State, what's your position on the bond?
$500, Your Honor.
All right. Any arguments to the bond?
Not knowing what his record is, that's the schedule. I mean, we'd be asking for PTR, but...
That's the schedule. We'll give you one moment. Let's see.
He has an extensive record.
He does. Yep. Is there a parole violation pending?
Not to my knowledge.
No, that's spelling. But you're right. That was on the underlying charge. It's fair to say that I think that it's a fair characterization to say that his record would be extensive. $500 is a reasonable bond under the circumstances. $500. Don't possess any illegal drug paraphernalia and appear for your next court date on January 29th as reflected on the paperwork I directed you to sign. Thank you. What's that?
Any other cases?
I'm inquiring. Do we have any other matters this evening, this afternoon?
I don't believe so, not for regional.
Your Honor,
Okay. Any other cases at all?
Yes.
Who would that be?
Well, we still have Mr. Turner, and we still have Mr. Austin.
Yeah, Turner and Austin.
Okay. Well, just stay in line for just a moment. Mr. Turner, would you come on up to the microphone there, please?
Yes, sir, Your Honor. I would like to go ahead and take them 30 days and plea out to it and get this done.
Okay. Do you want... You recognize that that may give them a basis for violating your probation in Arkansas if you do that. Do you understand?
Yes, sir. Yes, sir. I'm fully aware of everything that's going on, sir.
All right. Knowing that this may be a basis for a violation of probation on a felony burglary charge in Arkansas, do you still want to enter that plea, or would you like to hold off on that and talk to a lawyer?
No, sir. No, sir. I'd like to go on and plea out to it and get done. I'm fully aware of everything that's going on back home, Your Honor, and here. And I think it's in my best interest to take 30 days, get this over with, and go do what I got to do up there.
Mr. Turner, who else do we have other than Mr. Turner?
Mr. Austin.
Mr. Austin's back, right?
Yes.
Was Mr. Austin the regional conflict counsel case?
No, he's Mr. Germain.
Mr. Germain, that's right. I haven't heard back from Mr. Germain. That's all for regional conflict counsel.
All right, Your Honor.
Ms.
Have a great
Feinstein,
rest of your afternoon.
you too. Have a good day.
Take care.
Your Honor, is there no way that...
What?
Is there no way that
Yes.
I could take a fine for this or something? Or, I mean, I'm a welder. I weld for a living. That's what I do, you guys. So I was just wondering. I was hoping maybe a fine or something. I can go home, do what I got to do, pay a fine, whatever. But if I take 30 days,
I really am uncertain about this at all, because the 30 days could pale in significance to what you could be receiving based upon this plea in Arkansas. So I'm not sure why you're worried about the 30 days. It could be years that you could be exposing yourself to.
Well, this is what I'm looking at in Arkansas. They can give me no more than 6 months. I know that for a fact, and I've already got that on my mind. All right, to do 6 months. So no matter if I plead guilty to this or not, I'm not going to do any more than 6 months in Arkansas.
Where did you get that idea?
Because I've violated parole several times. I've been doing this for years with the state of Arkansas, and I know how it works. That's the honest to truth, God. Anytime you violate, they got a point system up there. The first time you violate, if you get too many points and you violate, they give you like drug classes if you fail a drug test. Then the second time, they give you 2 days in jail, then 2 weeks in jail. And then it's up to your parole officer after that whether or not they want to send you to 6 months. But 6 months is the most they can give you on a parole violation in the state of Arkansas.
Right. I have a suggestion for you. There's a potential. Let me ask you a question. Are you aware that under Arkansas law there are minor parole violations and major parole violations? Have you heard that?
Yes, sir. I've been doing this for about 10 years now.
Okay, so you recognize that they're divided into 2 different groups.
Right.
If this was on a major parole violation, if they characterize it like that you could get more time than what you have described. Do you understand?
I do understand, Your Honor, and I got about a year of parole left. So whatever happens, I'm ready to do it. I just want to be done, Your Honor.
All right.
I just want to be done, Your Honor. I appreciate your concern. I just want to be done with this, Your Honor.
All right. You understand the terms we outlined before?
Yes, sir.
Is that right?
Yes, sir.
Are those terms acceptable?
Yes, sir.
Has anyone promised you anything or threatened you with anything other than those terms in order to get you to enter a plea of guilty or no contest?
No, sir.
Are you feeling pressured or coerced in any way to do this?
No, sir.
Would it be true to say, Mr. Turner, you're entering this plea of your own free will?
Yes, sir.
Are you under the influence of any drugs or alcohol?
No, sir.
Are you thinking clearly and using your best judgment?
Yes, sir.
Did you read over that plea form carefully on both sides?
Yes, sir.
And did you sign it where your signature appears there by the word defendant?
Yes, sir.
Do you understand all the rights you're giving up and all the consequences of entering the plea as set forth in the form?
Yes, sir.
Is there any part of the form you didn't understand?
No, sir.
Now, you understand how you may be exposing yourself to a parole or probation violation in Arkansas. Do you understand?
Yes, sir.
All right, now, what you're pleading to is this. You're pleading no contest to resisting, obstructing, or opposing a law enforcement officer who is then engaged in the lawful execution of a legal duty. That's what the state would have to prove, and that's what you're pleading to. Do you understand?
I do understand that. Yes, sir.
Now, but for the plea agreement, this would be punishable by up to a year incarceration and a fine of up to $1,000. That's the statutory maximum. Do you understand?
Yes, sir.
Among the rights you're giving up is right to a jury trial. You won't be having one in your case if I accept your plea. Do you understand?
Yes, sir.
You understand you have the right to an attorney to represent you, and if you couldn't afford a lawyer, counsel would be appointed to represent you. Do you understand?
Yes, sir.
You understand what? You ever been represented by a lawyer in the past?
Yes, sir.
So you understand what the role of a lawyer is, how a lawyer would represent you, defend you in this case. Do you understand?
Yes, sir.
You understand a lawyer can be very, very valuable to you. Do you understand?
I do understand that, but I haven't had too much luck with lawyers. That's why I always represent myself.
Well, okay, you're not going to hold it against some lawyer you don't even know that you may have had some bad experience with a lawyer, are you?
I understand this, Your Honor. I understand it. And
So
I do understand all
you're
that stuff.
consciously your right to a lawyer. Is that so?
Yes, sir.
All right. Do you have any questions?
No, sir.
All right. You seem pretty clear about this. Is it your understanding that entering this plea is in your best interest?
It's in my best interest, Your Honor.
Very well. Find the plea freely and voluntarily entered with knowledge of its meaning and possible consequences. Upon a valid waiver of the defendant's right to attorney, I make those other findings that are set forth in the form and accept the plea. There being no legal cause why I should go forward, adjudicate guilt, sentence the defendant 30 days in the Brevard County Jail with... Oh, by the way, I have another question for you. Have you heard that the sheriff can reduce someone's sentence there in the Brevard County Jail by a certain amount of time per month?
No, sir.
Have you heard that?
No, sir.
You have not heard that?
No, sir.
Okay.
What I got to do to make that happen?
Well, if you behave yourself, then they may give you some time off, but that's not guaranteed. If you misbehave, you can lose that. Do you understand?
Your Honor, you have no worries here. I'm here to do one thing and one thing only. That's take care of me and get home to my family.
30 days in Brevard County Jail. What credit does he have, Kara?
2.
With 2 days credit for time served. Pay the court costs and $130 cost investigation to the Cocoa Beach Police Department. Any objection to a year to pay, State?
No, Your Honor.
A year to make the payments, and you're advised, sir, that you have 30 days in which to appeal this to a higher court. You have the right to an attorney to represent you on that appeal, and if you can't afford one, counsel would be appointed for appellate representation. Please sign the paper the clerk will give you, and that will conclude your appearance.
Thank you. Have a great day, Your Honor.
Good luck.
God bless.
Sit down and read this. Put your name right there.
And that's, did we hear anything from Mark Germain? Did you get any email?
I haven't received anything.
Mr. Austin.
Austin.
Oh, I did receive something. Give me a moment. I received an email. Give me a moment, Mr. Austin. Let me find that. More accurately, my judicial assistant received an email, a very well-written and lucid email from the paralegal at the firm of Germain and McCarthy, which indicates that acknowledging that you had apparently failed to surrender yourself to the jail on December 18th, and it gives the case number, and a warrant was issued for noncompliance. The warrant was served today. It is my understanding that Mr. Germain will be representing him on this new matter, however, is unavailable to address the case at initial appearance. The defendant has been sentenced to jail in another case and would therefore unable to be released at this time anyway. And are you able to pass this message along to Judge Silverman at initial appearance? And my judicial assistant did so. So my intention, therefore, I understand that they will be coming in to represent you on this matter, but I'm going to take no action as to the bond and set you for your next court date on January 31st before Judge Atkin. Sign the paper the clerk will give you. Thank you. Does that do it?
Yes, sir.
Thank you.
Thank you, Judge Silverman.
Thank you.
Hey folks, if you love drama inside the courtroom, get ready for May of 2019. Court TV is back. We'll be on the air with gavel-to-gavel live trial coverage of the biggest cases in the nation.
Good morning, sir. Your name?
Elvin Sebastián Ortiz Colón.
What about Mr. Ortiz?
No, Benito Ocho Horta.
Oh, Spanish interpreter. Oh, okay. Okay, and that's the Spanish interpreter. Got it. Okay. I don't know if I did this or not. Good morning, sir. I'm sorry about the confusion. Could you please tell me your name again?
Elvin Sebastián Ortiz Colón.
Thank you very much, Mr. Ortiz. You are here in case number 19 CF 476. You were arrested, sir, for resisting a merchant and grand theft, third degree. I do find probable cause for both of those offenses, and I will appoint the public defender to help you with your case.
State has no objection to PTR.
I will take the pretrial release, Your Honor.
Okay, then, sir, I'm going to order that you are on the pretrial release program, sir. Okay? Thank you very much. Good morning, sir. What's your name?
Sam Russell.
Mr. Russell, you are here in case number 19 CF 491. You were arrested pursuant to a warrant where probable cause has been found. You have a bond of $1,000 on count 1, possession of heroin, and on count 2, it's set at $500, and that's for resisting an officer without violence. I will go ahead and appoint the public defender to help you with your case, sir. Okay? Thank you. I think it's the next one. Santiago Guzman, did you pull it? Okay, I thought, okay. Good, okay. Good morning, sir. What's your name?
Aaron Smith.
Mr. Smith, you are here in case number 18 CF 16127. That's an out on bond case. Excuse me. And you're also here on 19 CF 442, where you're charged with burglary of a dwelling. I find probable cause for that offense, and I will appoint the public defender to help you with that case. On 19 CF 442, sir, I'm gonna set your bond at $2,500. State, would you like to be heard on 18 CF 16127?
The state has not made a charging decision on that case. He was arrested on November the 11th.
Defense.
Your Honor, we'll ask you to take no action, Your Honor.
The court will take no action on 18 CF 16127.
Your Honor, would the court have any objection to setting bond on the burglary of a dwelling as if, even though proper cause has been found, but as if it was like a trespass? Per the arrest affidavit, my client was allegedly, he stated to the officer that he thought the home was vacant and the dirt bike was abandoned property. And since, taking abandoned property in the state of Florida is not necessarily a crime, I wanted to argue that there was no intent to commit a crime when he was taking the bike. So I was wanting to know if you would say.
No, I'm not willing to consider that at this time. I'm gonna leave his bond set at $2,500. Thank you. Thank you. Case number 18 CF 8785. This is a Miss Kelly Smith, failure to appear. She was arrested pursuant to a capias. The bond is set at none and will remain at none. I'm going to appoint the public defender to help Miss Smith with her case. Mr. Thompson, do you want me to reset that?
No, it's no need to.
Okay.
I'll waive the appearance.
Thank you, sir. Aaron Smith and Kelly Smith, is this the same person? Okay, okay. Oh, now I see.
Yeah. They got proper cause.
Good morning, sir. What's your name?
Curtis Spencer.
Mr. Spencer, you are here in case number 18 CF 14107 and 19 CF 443. In that case, sir, you were arrested for burglary of a dwelling and petty theft. I do find probable cause for both of those offenses and will appoint the public defender to help you with your case. I see that in the 18 CF 14107, you have a pretrial conference set February 25th.
Your Honor, we'd ask that in 18 CF 14107, the bond be revoked. That has case management on January the 14th. If they want to do a bond hearing at that point in front of the judge, we have no objection to that.
Defense.
I would ask that the court take no action or an alternative to revoke bond and set a new one.
All right, sir, I'm going to take no action on the out on bond case 18 CF 14107. Good morning, ma'am. Could you tell me your name, please?
Mary Tamboni, Tambone.
Ms. Tamboni, you are here on case number 19 CF 451. You were arrested for grand theft, third degree. I do find probable cause for that offense, and I will appoint the public defender to help you with your case. State, do you have any objection to an ROR on this matter?
I have an objection to an ROR, an objection to PTR.
Your Honor, I would, my client's 64 years old, 0 criminal history. I would ask that the court consider releasing her ROR on this charge, Your Honor, and allow us to address her case and help her outside of the Orange County Jail.
Okay, I'm gonna release you, Ms. Tamboni, on your own recognizance, okay? You need to appear for all future court dates.
Thank you so much. Thank you so much.
You're welcome, ma'am. And stay in contact with your attorney's office. This is 19 CF 462. Good morning, sir. What's your name?
Otis Warner.
Good morning, Mr. Warner. You are here on a charge of aggravated assault with a firearm. I do find probable cause for that offense, and I will appoint the public defender to help you with your case. I'll set your bond.
Your Honor, this is the case I did have a probable cause count on.
Oh, thank you for reminding me. Go ahead, counsel.
Per the arrest affidavit, it does seem like the two were fighting, and it could be said that maybe that both of them were throwing threats back and forth at each other. However, no firearm was located on my client at all, and it could appear that the threats that he was accused of making were in response to the alleged victim in this case saying that her brothers were going to come and beat him up. And I think the altercation was caught on video camera, Your Honor. And I would like to reiterate, like, no firearm was located. The arresting officer stated that no firearm was located, so I don't see sufficient evidence to support a charge of aggravated assault with a firearm.
Thank you, Ms. Thompson. State.
Your Honor, at this point, the defense has done nothing but speculate on people's mind frame at the time and what the defendant could have been thinking at the time. The defense could have put on his client's testimony to talk about what he was thinking or his state of mind, but the defense attorney has no way of knowing that. Based on, if you look at the four corners of the affidavit and take everything as true, which is all that the court is required to consider for probable cause, and then after determining whether or not there is probable cause, to then set a bond based on the nature of the charge and the criminal history of the defendant. Based on the four corners of this affidavit, the victim alleges that there was a gun that was brandished, a small black handgun was taken from the band of his waistband of this particular defendant and brandished. That would be enough for probable cause at this point of the process.
Your Honor, and just to put one more thing, we want to point out that the alleged victim in this case is his ex-girlfriend. In a situation
Thank
like...
you, Mr. Thompson. The court does find probable cause for this offense.
Without a firearm?
Yes, as arrested. Yes, the court does find probable cause for the charge for what Mr. Otis was arrested for. And based on his criminal history, the court is going to set his bond at $1,000.
We'd ask for no contact with the victims, no weapons, separate residences.
Yes, you're to have no contact with Primicia Nixon, and if you live together, so you're not allowed to contact her, obviously, or you can't live together. Thank you.
Your Honor, in the next case, Mr. Wesley's, I was not able to pull up the affidavit to issue warrant.
Okay, just 1 second.
I believe it was sealed on the clerk's side.
assuming that neither the state nor the defense had an opportunity to look at.
I was able to find it. I don't know if defense has or not.
Okay. Well, why don't I just address the case and appoint the public defender, and then we can maybe readdress it so everyone has an opportunity, because I'm just looking at it for the first time as well, so we can readdress it after I've read the document.
Okay, that's fine.
Good morning, sir. What's your name?
Here is Wesley.
Mr. Wesley, you're here on case number 18 CF 17864. Based upon your affidavit of insolvency, I am going to appoint the public defender to help you with this case, sir. I need a moment to review the probable cause affidavit before we proceed further with your hearing, and I believe your attorney would probably like an opportunity to review that as well. And so we're going to recall your case at 1 o'clock, sir. Okay? Thank you.
Jason, you had a chance to read the police report.
You did? Okay. The clerk has a copy of that for you, Mr. Thompson. And I'll give you, can I give you the space sheet too? Okay, perfect. 115. Good morning, ma'am. What's your name?
Faith Whiteman.
Ms. Whiteman, you are here in case number 19 CF 461. You were arrested for possession of a controlled substance and possession of drug paraphernalia. I do find probable cause for both of those offenses and will appoint the public defender to help you with your case.
No objection to PTR, Your Honor.
We'll take pretrial release, Your Honor.
All right, and I will order that you are released to the pretrial release program, ma'am. Thank you.
All right, thank you.
Good morning, sir. Your name?
I'm Eric Swerker.
Sir, you are here in case number 18 CF 15232. That is an out on bond matter, and in case number 18 CF 17769. That appears to have been a warrant that was signed by Judge O'Kane, probable cause having been found. In that matter, you have a bond on count 1, that's possession of methamphetamine of $1,000, and possession of a firearm and the commission of a felony. As to count 2, you also have a bond of $1,000 on that count as well, sir. I'm going to stay both of those bonds at that amount. State, can you tell me what the offense date was of the warrant, the 18 CF 17769?
Tell you that FDLE started testing, received information on November the 15th. So the incident would have had to occur before then, but I don't have the actual date in our system.
Okay, just a second.
It may be in the physical file, but it's not in online.
For the arrest warrant, it looks like the offense date for that is October 6th of 2018, which is before the date of the out on bond case that he's also here for, so I'm gonna take no action on 18 CF 15232 today.
Can you say the bonds on the 2 cases he has?
Yes, on the warrant? Yes.
And the failure to appear. So I have a DUI failure to appear in 18 CT 2003.
Give me 1 second. Yes, there is.
And what's the bond on that, Your Honor? I didn't have that. He was supposed to be seen for that today.
It's a $500 bond on that case, on the failure
bond.
to appear.
Yes, and sir, you're also here on 18 CT 2003. You failed to appear in that case and you were arrested pursuant to a capias. You do have a bond in the amount of $500, and I will appoint the public defender to help you with all your cases, sir. Thank you.
Thank you.
Yes, he has no prior conviction, right?
Good morning, sir. What's your name?
Chadwick Hanna.
Mr. Hanna, you are here in case number 19MM256 for charge of trespass after warning. I do find probable cause for that offense. Would you like the public defender to help you with your case, sir?
Yes, but I guess yes, so then I can ask him.
Okay, I just need to ask you a couple questions because you didn't fill out an affidavit. Sir, do you have a job?
Yes.
How much money do you make every other week?
Every other week, I make like $1,700.
$1,700 every other week?
Yeah.
Okay. Do you have any dependents?
No.
Okay, sir, he does not qualify, correct? No. Okay. Sir, based on your testimony today in court, you do not qualify for the services of the public defender.
Yeah, I think that figure was before taxes.
Okay. I don't think even after taxes he'll
Probably
qualify,
still won't make
right?
a difference, but I'll just.
Yeah,
Time out.
I don't think he'll qualify. I can double check with the clerk. Madam Clerk, does he qualify for that? Okay. State, is there an offer on Mr. Hanna's case?
A withhold 5 days, no return to any Disney properties.
Okay. Mr. Hanna, the state has made an offer on your case today of a withhold of adjudication, which means you would not be convicted in 5 days in the Orange County Jail. Sir, based on your history and the offense, I would release you on your own recognizance today. And you would have an opportunity to hire a lawyer to help you with this case. What would you like to do? Take the state's offer or hire an attorney?
I would like to go today.
Okay. I'm going to release. State, would you like to be heard?
Yes, Your Honor, state would object. He does have out-of-state histories for failure to comply, thefts, stolen property, and it looks like a domestic violence case as well. So we would, based on his prior criminal history, out-of-state, object to an ROR.
Thank you, State. Sir, I will release you ROR. Yes, sir, on your own recognizance. Thank you. Good morning, ma'am. Your name?
Heather Keaton.
Good morning, Ms. Keaton. You're here on case number 19MM261. You were arrested for possession of drug paraphernalia and possession of cannabis less than 20 grams. I do find probable cause for both of those offenses and will appoint the public defender to help you with your case.
State has no objection to ROR.
Okay. Ma'am, I'll order that you be released to ROR on your own recognizance without posting a monetary bond, okay?
Thank you.
Thank you. Have a great day.
You too.
Good morning, sir. Your name?
Derek Meagard, Your Honor.
Hey, good morning, Mr. Maygard. You're here on case number 19MM255 for a charge of trespass after warning. The court does find probable cause for that offense, and I will. Would you like the public defender to help you with your case, sir?
Yes.
Okay. I have to ask you a couple of questions before I do that. Do you have a job?
I'm seasonal, so right now, no.
Okay. So where do you live?
Here on Colonial.
Okay.
I go back and forth because work is on yachts, so I'm in Alaska, I'm in Mexico, and I live here in Florida for the last 2 years. I would call my main residence.
I see. Okay. So I am going to appoint the public defender to help with your case based on your testimony. State, would you like to be heard with respect to the bond amount?
No to the hearing of the bond amount. The offer is a withhold, 3 days, no return.
Okay. Mr. Thompson, would you like to speak with him about that?
He has 2 days in, right? And he has out-of-state convictions, you say?
Yes.
And Your Honor, if he decides not to take the deal, what would you set the bond at?
Well, I just want to know if he wants to accept the offer or not before I set the bond.
RR a possibility? Because if he is to be released RR, he probably would consider fighting the case downtown.
Not based on his testimony. He told the court that he works on yachts and he leaves town, so I just have concerns about him coming back to his court dates or being here for court, so I would not release him ROR.
All right, we will accept the state's offer and enter a plea of no contest.
Okay. Mr. Maygard, I have your plea form, and your attorney informed me that you'd like to accept the state's offer. It was an adjudication of guilt in 3 days with credit for time served. Is that correct, State?
Yes, Your Honor.
Thank you. Is
No,
that
it's
correct,
a
Mr.
withhold,
Maygard?
Your Honor.
I'm sorry, yes, Your Honor, it was a withhold. I apologize.
Thank you. I apologize, Mr. Maygard. The state's offer to you was a withhold of adjudication with 3 days in the Orange County Jail with credit for time served. You'd like to accept that offer?
Yes, Your Honor.
Okay. I saw you sign the plea form here in court today. Did you read the plea form before you signed it?
Yes, Your Honor.
Okay. And did you understand the plea form?
Yes, Your Honor.
Do you have any questions about any of the rights that you'd be giving up today?
No, Your Honor.
And do you understand that if you're on probation for anything, anywhere, that this plea could violate that probation?
Yes, Your Honor.
If you're not a U.S. citizen, this plea will subject you to deportation. Do you understand that?
Yes, Your Honor.
Okay. If you've ever been convicted of a sexually motivated or violent offense, this plea could also, just let me finish, this plea could also subject you to involuntary civil commitment. Do you understand that?
Yes, Your Honor.
Have you taken any drugs, alcohol, or medication that would affect your understanding of what we're doing here today?
No, Your Honor.
Thank you. I do find that there is a factual basis to support your plea based on the charging affidavit. I'll withhold adjudication. I'll sentence you to 3 days in the Orange County Jail with credit for time served. You will need to pay court costs by January 10th of 2020. And you have 30 days to appeal the judgment and sentence of the court, and that must be in writing. Thank you, sir.
Thank you.
Okay. Case number 19MM262, Eric Riddle. He's charged with possession of drug paraphernalia. I do find probable cause for that offense. And I will appoint the public defender. Temporarily to help him with his case. And I'll stay the bond at $500. Mr. Thompson, do you want Mr. Riddle to come back tomorrow?
Hey, I'll roll in one time, Your Honor, so I'll roll in one time, see if he'll come tomorrow.
And then Mr. Riddle also has case number 18 CF 10885. In that case,
Which he could possibly be held at no bond, so that's why I would roll in one time.
okay, there's two separate things here. I see, okay. So then on case number 18 CF 1885, I'll take no action today and we'll readdress it tomorrow when he comes back. The out on bond case?
She's just gonna readdress everything tomorrow.
Yes.
Okay.
Thank you. Thank you. Good morning, sir. Your name?
My name, Your Honor, is Ivo Robuti.
Good morning, Mr. Robuti. You're here on case number 19MM269. You were arrested for trespass. I do find probable cause for that offense, sir, and I will appoint the public defender to help you with your case. State, do you have an offer for Mr. Robuti?
We'll just take the bond, Your Honor, we're going to entertain the office today.
Okay.
Your Honor, he is on probation. There is a 5-day hold in place for probation.
I see that.
Yes, and he also has reporting requirements, so he needs to report his address. once
Yes,
he's
I do
released.
see that here. Thank
Okay.
you very much for
You're
pointing that out
welcome.
to me. Sir, I'm going to leave your bond set at $500 on this matter. And as corrections just stated, you do have reporting requirements. So when you are released, if you post the bond, you need to report to the law enforcement, to the sheriff's office, okay?
May I say something, Your Honor?
I wish that you wouldn't, because everything that we say in here is recorded. So you should talk to your attorney and not to me, okay? I don't want you to say anything that could affect your case at all.
Sorry, Your Honor.
That's okay. Have a nice day, sir. Isn't that? Thank you. Good morning, ma'am. Your name?
Lynn Starling.
Hi, Ms. Starling. Good morning. You're here on case number 19MM263 on a charge of possession of drug paraphernalia. I do find probable cause for that offense, and I will appoint the public defender to help you with your case.
No objection to ROR, credit for time served.
Mr. Thompson, would you like to speak with your client about that?
That's adjudication, right? I will accept the state's offer and enter a plea of no contest, Your Honor.
Okay. Sterling, your attorney just informed me that you'd like to accept the state's offer of an adjudication of guilt and credit for time served as to this charge and enter a plea of no contest. Is that correct?
Yes.
Okay. I saw you sign the plea form here in court. Did you have an opportunity to read it before you signed it?
Yes.
Did you understand the plea form?
Mm-hmm.
Do you have any questions about any of the rights on this plea form?
Mm.
Do you understand that if you're not a U.S. citizen, this plea will subject you to deportation?
Yes.
Okay. Do you also understand that if you're on probation for anything anywhere, this plea may also violate that probation?
Yes.
If you have a history of a conviction of a sexually motivated or violent offense, this plea could also subject you to civil and voluntary commitment. Do you understand that?
Mm.
Have you taken any drugs, alcohol, or medication that would affect your ability to understand what we're doing here today?
Mm.
Okay. I do find a factual basis for your plea based on the charging affidavit. I will adjudicate you guilty and sentence you to credit for time served. Ma'am, you do need to pay court costs. Those are due by January 10th of 2020, and you have 30 days to appeal the judgment and sentence of the court. Must be in writing. Thank you, ma'am. Robin, is this crossed out because it's a no? Okay. Oh, he did? Oh, okay. Thank you. It's okay. Okay, Dexter. Good morning, sir. What's your name?
Matthew Michael Williams.
Mr. Williams?
Yes, ma'am.
You are here in case number is 18 CF 15575 and in case number 18 CF 18270. And you're also here in 19 MM 257, and that's for trespass. I do find probable cause for that offense, and I will appoint the public defender to help you with that case.
Have a moment, Your Honor.
Sure. Okay. Is there an offer on Mr. Williams?
No, Your Honor, we want the bond revoked in 18 CF 8720. Have a pretrial conference on January the 23rd, and it's a Division 14 case.
Okay.
He's out on bond committing new crimes.
Would that be your position on 18 CF 18720 as well?
Yes.
Mr. Thompson?
I would ask the court to take no action or to alternative to revoke those bonds and set new ones. I believe he has family members that maybe want to testify. I don't. I think he has family members said that maybe he wants to talk on his behalf.
Ma'am, are you related to Mr. Williams? Okay. Would you like to address the court? Okay.
Good evening, good morning.
Good morning, ma'am. Hold on one second, please. Madam Clerk, please swear her in. Thank you.
Use your right hand. Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please state your name for the record.
My name is Valerie Newton. I am his mother, and also I'm his payee, and I take care of him. He's incompetent, and he have a mental defect.
Okay, thank you. I just noticed here, I want to look up these two cases. I don't know if there's any orders that have been entered in those cases as to his competence.
When I looked up this morning, at least in the 18 CF 872, there was not.
Okay.
I can look up the other case right now. Give me one moment. Yeah, I don't see, again, A720
There
has
any-
nothing,
I'll
and then
just look.
the other case is 15575. And the 18 CF 15575, that case has a trial management, a pretrial on January the 23rd. There is not anything, no competency motions or doctor's evals in that case. Now,
He
here's the
already have taken them. He already did the evaluation. They decided that he was incompetent on this case, and he is in right now. He's in a competency restoration program.
If he, Your Honor, it's not on those two cases. It may be another case that he's out, and I can look to see if there are any. There are other cases? Okay, so.
I just want to take a minute, okay? I'm just going to take a quick break. So you said 3014? I'm looking at, that's an older case, in case number, there's a new one? Yes. Because in 13 CF 3014, that one was dismissed because he wasn't able to be restored to competency. Okay. State and defense, I'm looking at case number 16 CF 15115, if you'd like to take a look at that.
15115, you said?
Yes.
That has another status date, April the 5th. Competency status, he's been, yes.
Can I finish? Can I finish speaking?
Ma'am, if you could just give me 1 minute, and I'll
Okay.
let you finish what you want to say, okay?
All right.
Thank you. You said 15115?
16. State's recommendation would be that stay the bond in 819 MM 257 and take no action on the out of bond cases, the ones that he's already been judged incompetent, and the ones that he hasn't, let the public defender's office file necessary motions in those cases.
Defense.
Of course, to take no action on the Allen bond charges, Your Honor, and I would ask the court to release ROR since this particular charge here is not of a violent nature into the care of his mother, of course, Your Honor.
The only concern state would have is that the 16 case, he's picked up a number of cases since then. So it's just to release him RRR. He continues to commit crime. And if he's been in his mother's custody this entire time, she doesn't have enough supervision of him.
That's my
through
problem.
no fault of hers, that to make sure he doesn't continue to commit crimes based on his competency issues.
My problem is, since my husband had passed last year, that's when he been starting to get in trouble. I have to work now. Usually I didn't have to work. Now I have to work, and I can't keep an eye on him, and I don't have nobody else to supervise him. But then me and my mom been discussing it, that when I go to work now, she'll be able to watch him more. Because usually I just leave him to the house, and I be done cooked everything before I go to work. But now we see that he been staying out of trouble. It's just that yesterday he went to the grocery store with his grandmother, but he didn't know that he ain't supposed to be in there, nor did she know that he wasn't supposed to be in there. They were just doing grocery shopping. The lady just seen him, then said he trespassing.
So at this time, your mom, his grandmother, is assisting you in caring for him, and she's present also in the court?
Yes.
Okay. What's her name?
Annie Mae Robinson.
Does Miss Robinson live with you, ma'am?
No, she doesn't, but she don't mind picking them up, and I'm dropping them off when I go to work.
Okay.
She stay like a couple of blocks from me.
I'd like to hear from Miss Robinson as well, ma'am, if you would come forward. Thank you.
Yes, good morning.
Hi, ma'am.
Would you raise your right hand? Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God? Yes. Please state your name for the record. Annie Mae Robinson.
Miss Robinson, how do you know Mr. Williams?
He's my grandson.
Okay. And I just heard from your daughter that you have agreed to assist in supervising Mr. Williams if he was to be released. Is that correct?
Yes.
Okay. Do you have any concerns about your ability to supervise him while in
No.
your care?
No.
No. Okay. And if you did, would you report those to the police?
Yes.
Okay. State, would you like to ask any questions of either of the witnesses?
No question. I have no question, Your Honor.
Okay. Defense? Okay. So I'm looking at case number 16 CF 15115. There already is an order finding Mr. Williams incompetent to proceed in that case, and he's participating in the competency restoration program.
Your Honor, what is the date on that order?
The order is
Okay, it looks like he was found incompetent on August the 4th, 2017.
Yeah, I think it's the 4th, yes, it's correct.
Your Honor, I believe the case law says now that an evaluation that's more than 4 months
Just
old.
did one, excuse me, he just did one on December, at the end of November, because I took him to the public defender office.
An evaluation.
He talked to a psychiatrist.
An evaluation that we have the report on, more than 4 months old, is not fresh and new. They would have to do another evaluation to make sure that he's continued to be incompetent. He's not been judged not guilty by reason of insanity, which is different than competency. Competency is a continuous effect. So based on that information, maybe the public defender's office has a current one from an evaluation he's done in the last 3 months. It's not present before the court. The state attorney's office has not seen it as of this hearing. So we would request, again, no action on the out-on-bond cases, set a bond, or HPTR.
And, Your Honor, in response to that, I think it's clearly stipulated in the Florida statute that once a person is declared incompetent to proceed, he can't proceed in any other further cases until he's deemed competent to proceed.
So I'm also looking at a memorandum that was filed by Alvin Butler, who's the competency program director. That was in October of 2018, updating the court that he was not competent to proceed and he was not actually ready to be reevaluated. That was in October. It appears based on this testimony that he may have been. I don't know the outcome of that. But based on the testimony, based on Mr. Williams' other cases and the information that the court's reviewed in that, I am going to take no action on the out-on-bond cases, and I'm going to release him ROR into the care and custody of Miss Robinson and Miss Green, or I'm sorry,
Valerie Newton.
And Miss Newton. Thank you.
Your Honor, also, I just wanted, this is the number to our office, so you can stay in contact with us. I want to give this to you guys through the mail slot.
May the court take like a 3-minute recess?
Sure.
Thank you.
Okay, we're back on the record. Good morning, sir.
Hi.
Mr. Horton, you were here yesterday and I reset your case,
Right.
or your cases, so that we could have an opportunity to contact Mr. Lindsay's office.
Yes.
Were you able to get in contact with his office?
From what I understand, my family was in talks with him last evening.
Okay.
I had a chance to talk since.
Okay.
Additionally, I have the owner of the home for the case that I'm here for in there.
He's private, right? Am I correct?
He is.
But I'm not sure if, obviously no one's here yet today, but that's, last I heard, they were talking to him,
Okay.
trying to figure something out real quickly, you know?
Sure. My office did reach out to him, so maybe he was talking to your family, I'm not sure.
Yeah.
So we're here on case number 19 CF 403. No, I apologize, that's not correct.
It's the,
We are here on case number 19 CF 432. This was a reset from yesterday. The court does find probable cause for both of those offenses. And as stated before, you don't qualify for the public defender and you're working on hiring your own lawyer, which you will need to do. You also are here on two cases in which you are out on bond for, which is 18 MM 11743. That's a trespass on property after warning. And in case number 17 CT 7020. And that's a driving while under the influence.
yeah, it's a fairly older one.
Excuse me?
I think that's fairly old, yeah, going to trial on that one.
State, do you know the status of the CT case?
In 18 MM 11743, that was a 12/31 arrest. We'd ask the bond be revoked, and he'd be held at no bond, as then state has not made a charging decision, but it's so quick in the arrest. In 17 CT 7020, that has a pretrial conference date on February the 4th. We'd ask the bond be revoked, and he'd be held at no bond on that case as well.
Oh, we're gonna go off the record, just 1 second. Okay, and we're back on the record. Sir, did you say someone was here on the 19 CF 432, the burglary of a dwelling case?
The actual owner of the home, yeah. Right
Okay.
there, my
Did you,
mother-in-law.
it's your mother-in-law, did you want her to address the court?
Sure.
Okay.
Anything she could say could only help, I hope.
She owns the home?
Yes. Her daughter was just angry at me for being late.
Sir, I just am gonna ask you not to talk to me about the facts of your case, okay? Not because I don't care, but just because I don't want you to do anything that could jeopardize your case later on, okay? Good morning, ma'am.
Good
The
morning.
clerk's gonna swear you in.
Raise your right hand. Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record.
My name is Graciela Alzueta.
Good morning, ma'am. What is it that you'd like to tell the court about this matter?
Es posible que somebody help me? My English is little poor.
If she needs an interpreter, have to go to courtroom 2 in second session, Your Honor.
Okay. Mr. Horton, if you'd like, we can do that, but I was just gonna take her testimony for terms of deciding what your bond is. I can do that without hearing from her on the burglary charge.
Try one more time, maybe. I don't
State
know.
would object if she's not all the way to understand English. If he wants her to testify, it would have to be in courtroom 2 second.
Is that
session.
Correct,
What do you
right.
recommend?
Well, I can't give you any legal advice.
I own a business here. I'm trying to bond out, that's really the goal of today.
Okay. Well, having said that, sir, on your out on bond cases, I am going to revoke your bond and set those at none, okay? Because you were out on bond on 2 separate cases, one with an arrest that was just on 12/31 of 18. And now we have this new case here, so those 2 cases will be set at none. And on the 19 CF 432 count 1, I'll set your bond at $2,500 and I'll leave count 2 at $100. Thank you, sir.
So I can get out?
You're gonna need to contact the attorneys who represent you on the 2 misdemeanor cases, so that they can help you get a bond hearing set in front of the judges downtown where those cases are currently pending, okay?
Okay.
All right, good luck, sir. Good morning, sir. What's your name?
Hewlin Melton.
Good morning, Mr. Mountain. You are here in case number 19 CF 403. Excuse me. This was reset from yesterday morning. You are also here in, it's Mr. Mountain, correct?
Yes, ma'am.
This is a reset for probable cause not being found. May I approach the court?
Yes, you may.
This is the information we received yesterday via email from the arresting officer, which is the detailed information.
Thank you. Did you provide this to Mr. Thompson?
I did. I gave it to Mr. Thompson earlier for him
Thank
to
you.
review.
The court, having reviewed the additional information that was provided by the state, I'm going to find probable cause for the offense.
Then there was the 18 CF 16358. The state has not made a decision on that case. He was arrested on November the 16th.
Okay.
No objection and no action on that.
And the court will take no action on that matter. As to the 19 CF 403, the court will stay the bond at $500 and appoint the public defender.
And we asked for no return, no contact with the victims and no return.
Yes, sir, you're to have no contact with any of the witnesses, and you're not to return to Home Depot, okay? Thank you. Good morning, ma'am. Your name?
Kelly Meredith.
Good morning, Ms. Meredith. You're here in case number 18 MM11674. This is a motion for non-monetary release conditions. Mr. Thompson?
I will rely on the, I'm gonna rely on the bond at face value, but for the court's consideration that she has been in custody since December the 28th. She's unable to afford a monetary bond. The bond that she's at right now is gonna be tantamount to holding her at no bond whatsoever, and the charges that are listed are not violent in nature. And I'd like to have her sworn in to testify.
Okay. Madam Clerk? Mr. Ms. Meredith.
Raise your hand. Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, I do.
Do you have anyone to
No, I don't.
Have you tried to reach out to any of your family members or anyone that you know to help you post your bond?
Yes, I have.
And they all said that they are unable to provide funds?
Yes.
If you are released today without paying a monetary bond, do you promise to attend all future court dates?
Yes, I do.
How long have you lived in the Florida, in the Central Florida area?
28 years.
Do you have an address that you could go to if you're released?
Yes.
Could you state that address for the record?
4613 Trout Avenue. It'd be in Sebring, or in Orlando, I have 718 Western Avenue, Orlando, Florida, 33872.
Do you have any money that you use to pay your own bond?
No, I don't.
Do you have any assets or anything that you pawn to get your money?
No, I don't.
No further questions, Your Honor.
State.
I have no questions for you, Your Honor.
Okay.
Just argument.
Thank you, Ms. Meredith.
Your Honor.
I just have argument, Your Honor.
Yes, state.
Okay. It looks like she was arrested on December the 28th, so less than 2 weeks ago. On this case, she has 6 priors. Some of those priors include this particular offense. So based on her extensive criminal history and the fact that she would know what it's to be arrested before and in this process, we would ask the bond continue to stay as is. The state hasn't made a charging decision, but that's because it's a 2-week-old case.
Mr. Thompson.
Oh, yeah, no, we would just ask that you release RR. And yes, she's been here 2 weeks, but for the argument as stated, she won't be able to afford that bond. So in another 30 days, her conditions won't change.
I understand. Robin, can you tell me if she has any failures to appear?
Yes, Your Honor.
Okay.
She is wanted, but they're not going to extradite, only in-state out of North Carolina for probation violation. She also has 2 holds out of Osceola County, one for failure to appear for VOP at a no bond status and another failure to appear. She also has 11 failure to appears in her history. Let's see, 6 felony convictions, 16 misdemeanors, 1 incarceration, where she was released back in 2002, and that's for a burglary charge. She does have convictions for trespass and extensive prostitution, disorderly conduct, burglary, battery, forgery, possession of cocaine, robbery, armed with a weapon.
Thank you, Robin.
You're welcome.
Mr. Thompson, I'm going to deny the motion at this time based on the number of failure to appears that Ms. Meredith has.
Your Honor, can I plea out,
Ma'am,
please?
No, I can't, I don't want you to talk to me because everything that you say in here is recorded and it can be
I know,
used
but my
against you.
public defender told me I could plea out today, if I could possibly plea out to these charges, so I can go to Osceola County, please.
She cannot plea out. The state has not made a charging decision since past her initial appearance.
State, I understand that, but looking at the facts of the case, would there be any offer that you would have made maybe at initial appearance?
No, Your Honor. The problem has been that, based on reading the statute and the case law, that once initial appearances happen, there is no ability to resolve a case. And so we've been as an office, we've been cleaning up doing that until an information has been filed. So at this time, the state cannot make an offer to resolve the case.
Oh, I'm sorry. I didn't mean to cut you off.
Okay. All right, thank you, ma'am.
And the bench wants to make an offer today?
Pardon me?
Make an offer, please.
I'm not willing to, Ms. Meredith, at this time. Thank you.
Someone from the attorney who's confidential will be in contact.
Robin, you said that she had 2 holds out of Osceola County for a VOP, so she will be sent to Osceola County, correct? Yes. Okay.
Your Honor,
Just a second.
do you have PowerPoint? You know,
Mr. Thompson, I might be willing to consider giving Miss Meredith a plea to the bench, but that would, you'd need to talk to her because that may violate her probation.
Oh, she's on probation?
Yeah. So why don't you go talk to her, leave everything as it is, and you go talk to her, and you can email my JA if there's a change. And you can file another motion. Okay.
Well, Your Honor, that particular case has been already assigned to an attorney in my office. I would email them and let them know about that.
Okay.
All right.
Good afternoon, sir. Your name?
My name is John Summers.
This is Mr. Cohen?
It does, and let me check my email, but I believe Mr. Cohen believes it's at 1 p.m.
Oh.
So yes, according to my email from the ASA downtown, Mr. Cohen believes that this is at 1 p.m.
Then we'll just reset it for 1 p.m. Sorry, Mr. Summers, your attorney is going to be here at 1 o'clock to address this matter, okay?
Okay.
Thank you.
Thank you.
Yes, I got an email this morning.
Yeah.
Your Honor, you guys don't have a record for John Snyder, do you? I have a motion to release RR.
Is it a 30-day motion? Or I thought it was a bond motion.
It looks like it's a 33-day. Mr. Snyder and same for Mr. Banks.
I don't have Snyder on my list of 33-day motions.
Yeah.
In case you didn't know, folks, Court TV is back. Beginning in May of 2019, we'll be back on the air covering the nation's biggest trials, most important cases, most compelling, dramatic moments you'll ever see on television on Court TV, May of 2019.
Assigned to the case to try to get you a reduction in the bond. Do you understand?
Yes, sir.
All right, thank you, sir.
Your Honor, the state would request an ankle monitor, given the nature of these offenses.
All right, I appreciate that, but I'll go ahead and leave it at the monetary amount. Thank you, sir.
Next court date's on demand.
Derek Washington.
PD approved.
So there's probable cause to believe that he committed a petty theft. Now from Walmart, what I'm gonna hear about is what's going on with these other cases that they think you're out on bond on. Sometimes while they're preparing for that, sometimes what happens is I revoke the conditions of release in other cases. Sometimes I don't revoke the conditions of release in other cases. Sometimes I keep the bond at the bond schedule for the new case. Sometimes they raise it instead of revoking conditions of release. But since I don't know what the status of those other cases are, I have no idea what's going to happen. So I'm about to find out the information.
Yes, Your Honor. He is out on bond and with PTR in the Osceola case 18 CF 4582, and out on PTR in the Osceola case 18 MM 3733.
Right. And do you know what those cases are and what the status of them are, or what at least the charges?
Let me see.
Your Honor, 18 MM 3733 is a trespass, and that's set for PTC on the 23rd of January. The other case, 18 CF 4582, has come into our office charged as burglary of occupied dwelling. We've received it, but we have not made a charging decision at this time.
When was he released in custody on that case if pretrial services knows that? The clerk just told me January 4th. All right, so the conditions of release on your current case, the bond is $500, no return to Walmart. But on the 18 CF 4582, I'm going to revoke the conditions of release, and your lawyer can go in front of the judge assigned to the case to try to get you a bond again on that case. Do you understand?
That's why I can't bond. If I pay it today, I can't bond out. I can't get out.
All right, it's a little bit more complicated than that. If you post the $500 bond on the new case, you'll be considered released on the new case. But the jail will hold you on the 18 CF 4582 until you go in front of the judge to try to get you a bond to readdress conditions of release.
Your Honor, what would you like to do with the Osceola case, 18 3733?
Well, since
he's out on PTR.
Yeah, since I revoked it in the 4582, I don't need to revoke it on the 18 3733. Doesn't mean the state can't go in front of the judge assigned to the case to try to get it revoked. Doesn't mean that the PD might. They can ask me to revoke it now if you want them to start getting jail credit, or I can just leave it the way it is.
So what is going on?
You wanted to get. He won't be getting any jail credit with that open case, Judge.
Yes, he's agreed that he would like to start getting credit time served for his trespassing case as well, Your Honor.
Okay, so I'll revoke the conditions of release in 18 3733. All right, thank you, sir. Next case is Johan Manin, also known as Johan Fernando Manin.
Yes, sir.
You're in custody based upon a capias that was issued after you allegedly failed to appear for court, and the bond on that case is no bond in 2018 CF 3789. Your lawyer can schedule a hearing in front of the judge assigned to the case to try to get you a bond. You do have a next court date of an arraignment of January 22nd at 8:15 in courtroom 5F, whether you try to get a lower bond or not, or whether you try to get a bond or not, okay?
Thank you.
Thank you. Next case is Naomi Verdejo. When you get to the podium, if you could tell me how to properly pronounce your name. Sorry about that.
Naomi Verdejo.
In this case, in this proceeding today, you have 6 cases, all of which are 6 different cases where there's a violation of probation filed. In each one of them, the bond was at no bond. Your lawyer can try to go in front of the judge assigned to the case to try to get you a bond. It looks like you have a next court date. Is it on February 1st on all of them?
Yes, Judge.
All right, so your next court date, unless you schedule an earlier hearing, will be on February 1st, okay?
Yes, sir.
Thank you. Any other case that we haven't addressed?
Court TV is back, folks. May of 2019, we relaunch. We'll be on television. Gavel-to-gavel coverage of trials. If you love courtroom drama, this is the place to be.
Good afternoon. My name is Judge Rupi. You're all here this morning for first appearance. The purpose of these hearings today are to make sure that there's probable cause for your arrest. Probable cause only means that it's more likely than not that you committed the crime in which you've been arrested. As you appear before me today, you're considered not guilty of what you've been charged with. That status will remain with you through each stage of these proceedings up until changed by the state attorney's office if they prove the case against you beyond and to the exclusion of every reasonable doubt. In all likelihood, you were either arrested on a warrant or a new charge. Either way, you were given a bond pursuant to the bond schedule for the 5th Judicial Circuit. Today, I will determine whether to keep that bond the same, increase it, decrease it, or whether there are any other conditions of pre-trial release which will be imposed upon you. You are entitled to have a lawyer represent you at each stage of these proceedings. If you cannot afford to hire one, I will appoint the Public Defender's Office for you this morning. You're also entitled to make a phone call to friends, family, or your counsel, know where you are. If you haven't had the opportunity to make that phone call, please let me know. I'll make sure you get that phone call today. Finally, and most importantly, you have the right to remain silent, and I encourage you to do so. These hearings are recorded, and there is an assistant state attorney in this courtroom writing down everything that you say. So anything you say about the facts of your case can and will be held against you in the prosecution of your case down the road. At this time, I'd like everyone to raise your right hand so I can place you under oath. Solemnly swear or affirm the testimony before the court will be the truth, whole truth, and nothing but the truth. Okay, go ahead and put your hands down. As I call your name, come forward to the podium. Leandra Mailhouse. Hi, can I have your date of birth, please?
10/8/1997.
Okay, ma'am, you are here this morning charged with 3 counts of burglary of a conveyance and 1 count of grand theft auto. The total bond amounts are $20,000. I did find probable cause for your arrest. Do you want me to appoint the Public Defender's Office to represent you?
Yes.
Okay, I'll appoint the Public Defender's Office. Does she have a prior record?
No, Your Honor.
1 minute. No prior record? And there was someone who wanted to say something for her?
Yes. Here is fine.
Oh, you have to come up here so I can hear you. Sorry. So everyone can hear you. All right, come up to the podium. What is your name?
Latina Fraser Brown.
How do you know Leandra?
I'm her mother.
Okay. All right, what did you want to say?
I'm calling, I'm pretty sure, I'm not for sure that you know that she's on the medical ward. Leandra has juvenile diabetes. She just had a surgery less than a week ago. So we're trying to work on getting her out. If you could lower her bond and either give her release on her own conscience is what I'm asking for.
Okay. Do you live in Hernando County?
No, we live in Pinellas County.
Okay. Do you have any family here in Hernando?
None. Have no idea why they was even here.
Well, you have some idea.
Yeah, now that I talked to the detective about it.
Yeah, okay. All right. Well, what I'm going to do is she has no prior record, right, state?
Correct, Your Honor.
Okay. So I'm going to give her a lower bond. I'm not going to ROR her, though. There's some serious charges, and she's looking at some serious consequences for them. So she needs to make sure that if she is bonded out, and you need to make sure that she's bonded out, that she makes it back to court. Otherwise, you're going to lose that bond money. It's going to
She will be here. I guarantee you that.
All right. So for the conveyance of burglaries, the bond amounts currently are $5,000 each, and I will set them at $2,000 each. And then she has the grand theft auto, also set that at $2,000. So it's going to be a total of $8,000. She needs to be back to court on January 16th at 8:30 in the morning. And that judge is very serious about his start time. So I would maybe prepare to be here at 8.
And what was that date again? I'm sorry.
That's January 16th.
Okay, no problem.
Okay?
Thank
All
you
right,
very
thank
much.
you. All right, thank you, Ms. Miguel. Dorian Black. Your date of birth?
March 30th, 2000.
You're here for 3 counts of burglary conveyance, 1 count of grand theft auto, 1 count of fleeing to elude, and 1 count of driving a suspended driver's license. Your total bond is about $26,000. I found probable cause for your arrest. Do you want the public defender's office to represent you?
Yes.
Appoint the public defender's office. State prior record.
Your Honor, he does have juvenile history, if you'd like me to go into that, Your Honor.
That's what I'm asking for.
Yes, sorry. Providing false name in 15, adjudicated delinquent, grand theft, adjudication delinquent in 2015, a robbery, adjudicated delinquent 2015, resisting without, adjudication delinquent in 15, no, robbery, it looks like it'd be the same one. Your Honor.
Okay. All right. Mr. Black, I have an address here on 9th Avenue South in St. Petersburg. Is that where you live?
No.
Where do you live?
4114 Fairfield Avenue South.
Where's that?
St. Petersburg.
Okay. How long have you lived there?
I don't know. Is that
Okay. A year? Less than a year?
less than a year?
All right. Do you have a job?
Yes.
What kind of work do you do?
Fast food.
I'm sorry. What kind of work do you do?
Fast food.
Fast food? Okay. Gotcha. All right. For the 3 counts of burglary of conveyance, I'm going to set your bond at $10,000 each. For the count of the grand theft auto, your bond is going to be $10,000. For the fleeing to elude, your bond is going to be $10,000. And for the driving unsuspended, your bond is going to be $2,000. It's a total of $52,000. We're going to see you back to court on January 16th at 8:30 in the morning. Daniel Dombrowski. Have your date of birth?
29.
You are here today because I guess you were in jail somewhere else when you had a court date here in front of Judge Hitzman back in June for a trespass.
Yes.
Your bottom amount on that is $10,000. State, do you know if there's a plea offer here to take care of this?
Your Honor, Mr. Dombrowski served a total of 220 days. That's including time from Pasco and Hernando. At this point, it'd be the time served offer, Your Honor.
Okay. Do you know how much time he did in Hernando, baby?
He did 5 days in Hernando and 215 in Pasco.
All right. All right, so you want to take care of your case today for time served?
That's possible.
Okay. Do you understand that by taking this plea today, you're giving up your right to go to trial?
Not just this, but the other.
Do you understand that by taking care of this case today, you're giving up your right to go to trial?
No, this is the charge. He failed to.
Do you want to you want to get out of jail today, right?
Yes.
Do you understand that in order to get out of jail today, you can take care of this case today, and that by doing that, you're giving up your right to go to trial?
Yes, ma'am.
Okay. So you would be giving up your right to confront the witnesses against you, call witnesses on your own behalf, and you're giving up your right to have the state prove the case against you. Do you want to give up all of those rights in order to take care of this case today?
Yes, that's fine.
With regard to this trespass charge, how do you plead and plead no contest?
Not guilty.
Okay. If you're going to plead not guilty, then we'll have to see you back to court on another day.
I don't really understand.
Okay. If you're going to plead not guilty, that means you're not resolving this case today, and that you want to go to trial, and we'll set you up for court on another day. If you want to plead no contest, that means you can't contest the evidence against you, and you're going to take care of this case today.
Yeah, I'll take it. I agree.
Okay. You want to plead no contest?
Yes, ma'am.
Okay. I'll accept your plea of no contest. I find it's freely and voluntarily entered. Adjudicate you guilty. Sentence you to 220 days in jail. Give you credit for the 220 days that you have in. You'll get cost of incarceration for the 5 days that you did in Hernando County. You'll have fines and court costs that you have to pay. It's just $553. I believe it's $553.
Okay.
Okay. So do you want just 90 days? Okay. So 90, and then 5 days in Hernando County. And then, so you owe the $553. You just need to make payment arrangements to the clerk of court for that, okay?
All right.
All right, thank you.
Sorry.
Robert Green. Date of birth? All right, you're here today for 3 counts of burglary of a conveyance and 1 count of grand theft auto for a total of $20,000. I found probable cause for your arrest. Do you want the public defender's office to represent you?
Yes, ma'am.
I'll appoint the public defender's office. State to see a prior record.
Yes, Your Honor. He also has juvenile history, a grand theft adjudicated delinquent in 2015, another grand theft arrest out of 2015, a burglary adjudicated delinquent in 2016, and another grand theft in 2016. And most of his history is out of Pinellas County.
Okay. Sir, I have an address here on 17th Street in St. Petersburg. Is that where you live?
Yes, ma'am.
How long have you lived there?
17 years.
All right. Do you have a job?
Yes, ma'am. No.
I'm going to set your bond at $10,000 each, and we'll see you back to court on January 16th at 8:30 in the morning, okay? Daniel Johnson. Hi, can I have your date of birth?
11358.
All right. You are here today for a DUI and an introduction of contraband into the jail facility. I found probable cause for your arrest on each of these. Do you want the public defender's office to represent you?
Yes.
I'll I'll apply to public defender's office. State, I already see that he's got a DUI from 1979, 1987, and 1991, so this would be a fourth. Is there anything else I need to know?
No, Your Honor.
Okay. Sir, I have an address for you on Pin Oak Road 2 in Tallahassee. Is that where you live?
Right.
How long have you lived there?
Since 96.
Okay. Do you have any family here in Hernando County?
Well, my wife, we came down, son got killed Friday. And we come down and get ready to bury him next week.
Okay. Do you have anyone else here in this county?
My wife,
She lives down here?
no, she don't live here.
Okay, well that's what I'm asking. Do you have any family members that live here in Hernando County?
No.
Okay. All right. All right, on the DUI, I'm going to set your bond at $2,000, and on count two, I'll keep your bond at $500. I'm going to see you back to court on January 16th at 8:30 in the morning, okay?
Okay.
All right. Jarrett Johnson? Have your date of birth?
7/26/88.
You're here today for a violation of probation. It's based on a warrant signed by Judge Toner on December 11th. There's probable cause for your arrest. He wants you held no bond until you can get there back in front of him. So we're going to hold you no bond. We're going to see you back January 16th at 8:30 in the morning. Did you want the public defender's office?
Yeah, could you tell me what the violation was?
Sure. It's a violation. You were placed on community control, and apparently you failed to remain confined to your approved residence on November 19th. They came out to your residence and you weren't there, okay?
All right, thank you.
All right. Leo Johnson? Date of birth?
9/27/71.
All right. Mr. Johnson, you have a couple things going on here. First of all, you have a failure to appear on a possession of paraphernalia that you're supposed to be in court in front of Judge Hitson on December 6th. He has set your bond on that at $2,000. Then I guess when you were arrested, you picked up another possession of paraphernalia. So that bond is $1,000. I found probable cause for both of those. And I also see that you have a pending case right now. Is that in front of Judge Toner? The driving on suspended driver's license?
Forget what his name is.
Judge Merritt?
The only Jim.
Okay. Doesn't matter. All right.
It is Judge Toner, Your Honor.
Doesn't matter. Okay. So you have an option today. If you want to resolve both of these possession and paraphernalia cases today, you can do that. I will sentence you to 90 days in the Hernando County Jail. We'll give you credit on one of those cases for the 2 days that you have, or we'll give you credit for the 2 days that you have in on those cases. Is that something you want to do today?
What's the other option?
The other option is you don't have to do that, and I can set you up for a court date for these cases on January 16th. But also what I'm going to do is I'll have to recommit you on the 2018 CS 1472.
I take it.
All right. You understand that by taking a plea on these cases today, you're giving up the right to go to trial?
Yeah.
Giving up the right to confront the witnesses against you, call witnesses in your own behalf, and you're giving up the right to have the state prove the case against you. You want to give up those rights in order to take care of this case today? Okay. With regard to the possession of paraphernalia, in 2018 MM231, how do you plead? Complete no contest. I'll accept your plea of no contest. I find it's freely and voluntarily given. Adjudicate you guilty. Sentence you to 90 days in the Hernando County Jail. Give you credit for the 2 days that you have in. You will have fines and court costs assessed against you for that, and the cost of incarceration. With regard to the new charge of possession of paraphernalia, what is your plea? Plea no contest.
No contest.
Accept your plea of no contest. I find it's freely and voluntarily entered. Adjudicate you guilty, sentence you to 90 days in the Hernando County Jail, give you credit for the 2 days that you have in. You also have fines and court costs in that case as well. And then the pending case of 2018 CF 1472, that will remain pending in front of Judge Toner on January 2nd. Okay? All right, Mr. Johnson, real quick, did you have the public defender in that? You have the public defender in that case, right?
Yes, ma'am.
All right, so I want to be out there to talk to you soon about that, okay? All right. Michael Lisk. Date of birth?
September 13th, 1987.
All right. You're here today for a commercial burglary and 8 counts of burglary of conveyance. That's for one case. Another case you have a grand theft auto. And then another case you have a fleeing to elude police officer. I did find probable cause for your arrest in each of those cases. Do you want the public defender's office to represent you?
Yes, ma'am.
I'll appoint the public defender's office. State prior record.
Yes, Your Honor. A possession of cocaine adjudication was held in 2007, 102 days in county jail. Failure to appear reference on Hernando in 2007. A battery disposition guilty in 2010 with time in jail for 63 days. Disposition guilty for disorderly conduct in 2010 with a probation violation. Disposition guilty in 2012, 117 days in county jail for battery. Violation of pretrial release in 2012, adjudicated guilty. A burglary in 2013, disposition guilty. Possession of controlled substance, disposition guilty in 2016, as well as a paraphernalia and a resisting. A petty theft disposition guilty in Hernando County in 2018.
Okay. Mr. Lisk, I don't have an address for you. Do you have an address these days? Where you living?
No, ma'am.
Okay. Do you have a job?
No, ma'am.
So for the commercial burglary, I'm going to set your bond at $10,000. For each count of the burglary of conveyance, I'm going to set your bond at $10,000. For the grand theft auto, I'm going to set your bond at $10,000. And for the fleeing to elude, I'm going to set your bond at $10,000. We're going to see you back in court on January 16th at 8:30 in the morning, okay?
Yes, ma'am.
Thank you. O'Mary and Nathan? Date of birth?
August 1st, 2002.
You're here today for an armed robbery and a burglary of conveyance. You have one count of each of those. For the armed robbery, your bond is $50,000. For the burglary, your bond is $15,000. I found probable cause for your arrest and it's based on a warrant signed by Judge Merritt on December 17th. Do you want the public defender's office to represent you in this case?
Yeah.
Okay, I'll appoint the public defender's office. State, is there a prior record?
Your Honor, yes, there's juvenile history. Looks like a burglary or trespass and adjudication of guilt in 2017. Burglary of a dwelling, disposition guilty out of Hernando in 16. Disposition guilty for exposure of sexual organs in 2017. Disposition guilty for petty theft out of Hernando in 2017. And that's all I'm showing, Your Honor.
Okay. All right, Mr. Nathan, I have an address for you on Warner Ave in Brooksville. Is that where you live?
Yeah.
How long have you lived there?
Like 2 years.
Okay. Do you have a job?
No.
All right. That address on Warner Ave in Brooksville, do you live there with your parents?
Yeah, my mom.
All right. I'm going to keep those bonds the same, okay? We're going to see you back for January 16th at 8:30 in the morning, and your attorney will be out to see you soon, okay? Brian Phelan? I have your date of birth?
11/29/83.
We're here today for a retail theft. It's based on a report from Walmart back on November 23rd. So I found probable cause for your arrest. Do you want the public defender's office to represent you?
Yes, ma'am.
Okay, you have them on your pending case already, the public defender's office?
Yes, ma'am.
Okay, go ahead and appoint them for you. And for the other case, you have not bonded out on that case, right? You've been in custody since you were arrested on that?
That's correct.
Okay. And that bond is just, what, like $1,000?
I really don't know, ma'am.
Okay. I have an address here on Candia Street in Spring Hill. Is that where you live?
Yes, ma'am.
How long have you lived there?
30 years? 20 years?
Do you have a job?
Yes, ma'am.
What kind of work do you do?
Carpenter.
I see that the most recent from 2016 is what I have for the stealing stolen property and depriving a pawnbroker. And then I have a whole bunch of other worthless checks and trespassing.
Yes, Your Honor.
Set your bond at $1,000. We're going to see you back to court on January 16th at 9 a.m., okay?
Yes, ma'am.
Tyrone Ross? Can I have your date of birth?
45/72/03.
Alright. You are here today for an armed burglary. The bond is currently $50,000. And burglary of a conveyance, the bond is currently $25,000. I found probable cause for your arrest and it's based on a warrant signed by Judge Merritt on December 17th. Do you want the public defender's office to represent you on this case?
Yes, ma'am.
Okay, I'll appoint public defender's office. State, is there a history?
2017 Marion County grand theft that was dropped, and a Hernando robbery was probably that's all, Your Honor.
What was that last one? Hernando what?
A Hernando robbery with a firearm, but it looks to be this 2018. It says November 27, 2018. So that's all I have, Your Honor.
Well, okay. Because the state offense was November 17th, so it's part of the same case.
That's what I'm believing, Your Honor.
All right. All right, Mr. Ross, I have an address for you on Flagler Ave in Brooksville. Is that where you live?
Yes, ma'am.
Okay, how long have you lived there?
All my life.
All right, do you have a job?
No, ma'am.
Are you in school?
Yes, ma'am. Yes, ma'am.
All right, are you in school full time?
Yes, ma'am.
All right. Are you here to speak for him? Okay, if you'd like, you can come. You don't have to, but if you'd like, you can come up and say something. What is your name?
Annie.
Okay. How do you know this guy?
I'm his grandmother, and he's been living with me all this time.
Okay.
And our thing is people, place, and thing. I'm asking you to lower his bond because he's never really actually been into any trouble. It's always the company that he keeps.
Well, the company you keep can get you in trouble.
Yes, ma'am, that's what I'm telling you. And I've been talking to him on and on about that. But since my husband died, I've been having issues, so I'm trying to get counseling. He just really started getting counsel for that. But my son, that he haven't seen in 4 years, are coming home for Christmas. And I know the bond was high for what he did, but...
Well, no, it's appropriate for what he did.
I just said, man, it's high.
Yeah, it's
you know
high,
what I'm saying?
but it's appropriate.
I can't afford
Yeah.
that.
Okay.
So,
I mean, have you spoken to the detective in the case and the state attorney's office to find out what exactly happened here?
no, ma'am, this is the issue. This is our first time getting involved in this period. It's my first time ever been here. The public defender that he had, Mr. David Bow, I have on my phone. I have been calling him for a whole week to get information on when this happened. With my grandson, I wasn't even home. So I was told that he had did that, but no one came to my house. It happened before Thanksgiving.
Yeah.
I was out of town. when I was out of town in Maryland with my son, I'm at the airport. I got a phone call from the school saying that they had removed my grandson from the school. So I called his mom, which all of them live with her, and she didn't get a phone call either. So what she did, she went to the police station looking, trying to find out what actually really happened. Okay, when she got there, nobody was, they told her that he hadn't got there yet. This is one of them by the credit union. Then they went to another. She sat there for an hour and a half before she could find out really whether they had him. So she had to rush and come to the airport to pick me up. So I called because he's in my custody. And I called and they said, well, ma'am, I can't give you any information. And we took him to the detention center. And then I said, then I called there. So the lady was telling me what he was charged for. And when it happened, I said, well, ma'am, I said, you know, I'm a Christian, I'm home. I said, this kid got in the trouble. If they would have came to my house and picked him up, you know, I would have felt more better. And I would say, here, either I would have took him there until we found out, you know, what's really going on. So anyway, to make a long story short, I just...
Well, you did not make that short.
I haven't talked with anybody, so I called this morning. I was praying. I said, well, Lord, who do I talk to? Because I've never been through this. So I called the public defender, and Mr. Bowles out again. I ain't spoken to him all the week, so I have another lady named Ms. Bell. She said, well, Miss Wheeler, she said, well, he has arrangement today. I said, well, I'm going to get dressed and rush down there and hope that I can get there to see what's really going on. So, honest, ma'am, I really don't know. I'll be honest. I've never been through this.
Okay. And I appreciate you being here. And no one is saying that you did anything wrong or whatever, but because these charges are so serious and because of what he did is so serious, he's being treated like an adult. He did an adult thing. He's going to be treated like an adult.
Yes, ma'am.
So he's not going to be given any coddling or checking with his guardians first or anything like that. So it's man up time. And this is a robbery with a deadly weapon. It's with a firearm. There was a gun involved. This is not. This is not a petty theft. This is not something where, you know, it's going to be anything good happening out of this. So, I mean, it doesn't look like, I mean, he's got a prior arrest that was dropped. I don't know if it was dropped because he went through a program to get that dropped. I'm not sure what the circumstances were. Okay. But here's the deal. He did some serious things, and we need to make sure that the bond is supposed to make sure that he comes back to court. So, if you're able to bond him out, I mean, he doesn't even, does he drive?
No, ma'am.
Okay, so who's going to get him to and from court?
I am.
You're going to get him to and from court?
Yes, ma'am. I promise you, yes, ma'am.
Okay. All right. So what we're going to do is I will go ahead and lower the bond a little bit because it seems like he's not really been in a lot of trouble before, and it looks like he's got ties to the community, and people are going to guarantee that he makes it to and from court. So for the armed burglary, I'll go ahead and set the bond at $10,000. And for the burglary of the conveyance, I'll go ahead and set that at $5,000. It's a total of $15,000. He needs to be back to court on January 16th at 8:30 in the morning. And I don't know if you were here when I spoke to those other people. That judge is very serious about his start date. If you guys aren't there at 8 sharp, then he'll take him into custody. So make sure you're there probably by 8. Okay?
Yes, ma'am.
All right. Thank you. Your attorney will be out there to see you soon. Okay, Mr. Ross?
Thank you.
Jackhead Rouse? Can I have your date of birth?
7/17.
You're here today for 3 counts of burglary of conveyance, 1 count of grand theft auto, and 1 count of fleeing to elude. I found probable cause for your arrest on each of these. Did you want the public defender to represent you?
Yes, ma'am.
Okay, I'll play the public defender's office. State their history.
Yes, Your Honor. Juvenile history, adjudication withheld in 2016 for a trespass, disruption of school function, a burglary of a conveyance in Pinellas County in 15, adjudication withheld, a burglary of a conveyance in 2015, another count from a different date in Pinellas County, no disposition, grand theft in 2015, grand theft of a motor vehicle, adjudicated delinquent in 16. A 2017 burglary, adjudicated delinquent. Probation violation out of 18 in Pinellas County. Another probation violation in September of 2018. And a vehicle, and that's this.
Mr. Rouse, I have an address for you on 24th Ave in St. Petersburg. Is that where you live?
Yes, ma'am.
How long have you lived there?
A few months.
I'm sorry?
A few months.
A few months? Okay. How long have you lived in Pinellas County? I mean, how long have you lived in Pinellas?
All my life.
All right. Do you have a job?
No, ma'am.
Okay. I'm going to set your bond at $10,000 each. And we're going to see you back to court January 16th at 8:30 in the morning, okay?
I ain't never got my phone call.
What you mean to say is you haven't gotten your phone call yet?
No.
Okay, well, make sure that you get that phone call today, okay? Gary Sharp. Can I have your date of birth?
6/13/78.
You're here today for a violation of probation. It's based on a warrant signed by Judge Merritt on November 15th. So there is probable cause for your arrest. He'll let you have no bond until you get back in front of him. So we're going to hold you no bond until January 16th at 8:30 in the morning. Did you want the public? Is that Judge Toner?
Yes, ma'am.
Do you want the public defender's office?
Yes, ma'am.
Okay. Is that the right date?
116?
Yeah.
Yes, ma'am. She's on first. That's the right date.
Okay. And that's Judge Merritt.
I have Judge Toner.
So I need a Judge Merritt date.
Judge Merritt, I have a 1/8 date.
Okay. So we'll see you back January 8th, okay?
Yes, ma'am.
All right. Thank you. Got everyone at the jail? Yes, ma'am. All right. Thank you.
I'm Vinny Politan, and yes, Court TV is back. May of 2019, we will relaunch. Keep your eyes open.